So you think because it's your own product, it can't be prior art against your patent application, do you? Then I have some bad news for you. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. Hey, if you like this content, please do me a favor and like, follow, and share. There's a misapprehension some of you have that your own products can't serve as prior art against your patent applications that may describe or claim those products. That is not true. If you put your product on sale, or if you cause it to be publicly used, or if you describe it in an advertisement or some other printed publication more than 1 year before you file for a patent application on it, you can be barred from later doing so. So you absolutely can create prior art against yourself. Now, that's a 1 year grace period. That applies to you putting a product on sale, publicly using it, or describing it in some kind of publication, okay? If somebody else does that, one of those activities, there is no grace period. But if you're doing it for your own product, then there is a 1 year grace period. But that is in the United States. In many foreign countries, maybe all of them, there is no grace period. So if you put an advertisement out even 1 day before you file for a patent application, that advertisement will act as prior art against you in that foreign country. Not too long ago, I had a client whose company, unbeknownst to him, put an advertisement for a product up on a website 6 months or so, I think, before we filed for a patent application on it. And then we found out later that this had happened when we got into the foreign patenting process, and that advertisement came out as prior art. It didn't cause a problem in the US because the patent application was within the 1 year grace period, but it definitely did cause a problem with foreign rights. So when you are commercializing products and filing patent applications that are intended to describe and claim those products, it is very important that you coordinate your commercialization activities with your patent filing activities. A lot of times the people that are sort of on the commercialization track don't know what's going on the patenting side, and vice versa. And this is where you can get into trouble by having something inadvertently disclosed well before a patent application is filed. You don't want that to happen. So you really need to closely coordinate those groups of activities to avoid creating prior art against yourself. I hope that helps to keep you out of trouble, and I hope to see you here soon.